we have to look at that early or the first injunction or the restraining order that the police sought from the High Court. So from the reports, okay, the High Court granted the restraining order indefinitely, okay, that until there's a lifting of the ban on public gathering, you cannot have it, okay. So that is when they went to court. Actually, you didn't go just because I've read the grounds for the supervisory invocation, but what you went to court to say is that the High Court actually acted out of jurisdiction, okay, because they can only give a 10-day restraining order in the case of ex parte applications, and then it was given beyond that, I mean limitlessly.
Okay, what, so the High Court's procedure rules? Civil
procedure rules.
Did the courts not know that? That's the question, the obvious question.
The court here, the lady justice probably would have definitely knew that, but I think because of the way the application or the motion was, couched, that because of the COVID restrictions, okay, so we are seeking this order because of that. Not because there is an emergency, if you don't do this, something will happen. But actually that should be the grounding for ex parte applications, that there's going to be an eruption, to use it crudely. There's going to be an eruption of something that will breach our public health, regulations. So please intervene. So the court, in direct response to it, will say that then until the ban is lifted. Okay, but that actually breached the law also. That's what the Supreme Court agreed with them. That not that you were not heard, but that the court, in giving the order, went out of its jurisdiction. Okay, so when, upon the expiry of the 10-day restraining order, that's when you now go on notice. And I could glean from what they said that is what they term as the substantive matter before the High Court. It's not actually the substantive matter. This is still the application for the restraining order, but this time you are letting all the parties come to court, debate probably if they want to oppose the motion, do so, and then at the end of the debate, the court will give a determination. So now the point is, what is the implication? What is the effect of this? The effect is that before the Supreme Court's quashing order or the intervention by the Supreme Court, there was this indefinite restraining order. So now that has been removed. So that's why you could hear Justice Apau asking that we will not even seem to be directly granting you what you are asking for, even in the first relief, because technically the maximum the court could give was 10 days. So once the 10 days has elapsed, there's nothing else to even to quash. So when we are even saying that, they quash, the court did not quash anything. The court said, by operation of law, the 10 days has expired, and there's nothing there. So
and from the period of expiration of the 10 days, can they do their protest? Or
they can do that, but the difficulty is you have to now go and comply with the Public Order Act, which means you have to give notification to the police. Because once this one has been more or less cancelled, the slate is cleaner. Okay, just that unfortunately you have at the end a pending
the June 14th
application on notice.